Ever since the Supreme Court's controversial ruling in the 2000 election, that Bush v. Gore case, the possibility that the justice might once again play a key role in deciding a presidential race has loomed over our politics. To be sure, it is, we think, an unlikely scenario this year, but a wave of lawsuits headed towards the court, some of which already reached the court, raises at least the chance that the justices could play an influential role in 2024. Here's ABC's Devin Dwyer with a look at what we should be looking for in the courts.
It's already the most litigated election in American history. Republicans and Democrats have bombarded state and federal courts with challenges over vote counting procedures, the purging of alleged non-citizens from voter rolls, and mail ballots missing dates or arriving late after November 5th. Allies of former President Trump say it's about ensuring election integrity.
This isn't about throwing an election. This is about having a system that works as best as we can.
But critics say the unprecedented legal onslaught is based on false conspiracy theories and aimed at tipping the scale.
What they're doing is they're trying to sow distrust in our election in order to set the stage for potential subversion.
4 years ago, judges appointed by both Democrats and Republicans in 60 cases across 12 states concluded the Trump campaign's election challenges came up short. Even at the U.S. Supreme Court, Trump's 2020 appeals were entirely turned away.
The good news is these went into court. Our justice system worked the way it's supposed to, which was one person making a claim they saw something doesn't result in a successful challenge.
But now the Supreme Court faces new opportunities to potentially influence an election outcome. Republicans in the key state of Pennsylvania want the justices to stop residents from getting a second chance to vote if their mail-in ballot was defective. In Georgia, Republicans are challenging mandatory certification of election results by a legal deadline. And cases from Mississippi and Nevada could allow the high court to decide whether mail ballots that arrive after Election Day must be discarded under federal law.
Are you confident our courts will faithfully uphold the votes if contested?
I am confident that the courts will faithfully uphold the law, because that is our duty. That's what we do.
Congress explicitly gave the Supreme Court the final word in disputes over the electoral vote count in an effort to avoid a repeat of January 6th. If a state were to refuse to certify its results, or if more than 1/5 of members of Congress later object to a candidate's electors, the justices would render a decision in what would be an echo of Bush v. Gore.
Our thanks to Devin. Let's bring in former Trump Justice Department official and ABC News contributor, Sarah Isgur. Sarah, thank you for joining us. So you spend a lot of time thinking, talking, writing about the Supreme Court. What do you think is the most likely scenario that we're all sitting around sometime between November 5th and January 6th waiting for a Supreme Court decision?
Well, obviously, it's a recount scenario. Like you were talking about with Bush v. Gore, that was a question over which ballots to recount, what ballots we're going to count, overvotes, undervotes, remember the hanging chads. The interesting thing is so many states have changed their laws. Florida, of course, now has one of the best election systems in the country. We expect to get their results maybe before any other state. Pennsylvania, Michigan, Georgia, for instance, all have recounts, but it has to be within a half of a single percentage point. That's where you're going to see litigation if the election actually comes that close in these swing states.
And we have to distinguish between legal challenges, which can be entirely appropriate. They are the right of a campaign, of a losing campaign or a campaign that is behind, to have legal challenges, and the kind of stuff we saw in 2020, which was an attempt to overturn an election through non-legal measures, having the states take back their certifications, have Mike Pence go in there and undo certified electoral votes. The one that I look at is this effort to try to to go county by county in certification, perhaps holding back certifications if the county doesn't like the results, if a county officials. Do you see this be something that could get to the courts, and how will the courts handle it?
Well, let me put these challenges in two different buckets, because even in 2020, a lot of the challenges, the legal challenges that we saw after the election were challenges that should have been brought before the election. How to count absentee ballots, who's on the voter rolls. Those type questions have to be answered beforehand. We do not litigate them afterwards. As you saw, there's a person being prosecuted in Michigan, for instance, for voting illegally. That ballot is going to count because once the ballot is in, we don't know who it belongs to. We can't pull it back. So all of those challenges have to be done ahead of time. That's why, as Devin said, this so far is the most litigated election we've ever had, with an average of one lawsuit per day in October, over 150 currently still pending. Now, after Election Day, we see a different type of legal challenge. That's how to count, how to certify the vote. As you said, who gets to certify is a process question that almost certainly will need to have been litigated beforehand. But if there's ambiguities, if we're not certain over whether an official must certify, shall certify, may certify, these are the words lawyers live for in statutes. And for those states who changed their laws after 2020, there could be ambiguities that we're not even yet aware of until we see the facts that may lead to us talking about them.
And then just one last one. We could talk for hours about all of the possible scenarios, but we had this Virginia case on the Virginia's efforts to purge voters who did not mark that they were citizens on their DMV records. I don't want to get into the details of the case itself, but what I noticed is when it went to the Supreme Court, and the Supreme Court decided whether or not it was going to deal with it, the decision was 6-3, and it was the 3 liberals versus the 6 conservatives. Is that what we're going to be looking at if we once again have a case that goes to the Supreme Court that's going to be broken down by? I mean, I thought there was no partisan way to count votes. I thought we just count votes.
Well, the institution of the Supreme Court is in such a different and more vulnerable place than it was in 2000 when Bush v. Gore was decided. This is a Supreme Court that is less popular than any Supreme Court in modern history. And it does look more often like it's breaking along those 6-3 lines, as you saw in that Virginia case. Now, what's interesting about that, the Supreme Court intervened in Virginia, but not in Pennsylvania or in Nevada, for instance, and Michigan, another one. Why? Because those were state courts deciding issues of state law. In Virginia, you had federal courts stepping in here within 30 days of an election, and the federal courts have a rule called the Purcell principle that federal courts will not get involved. So really what it looks like the Supreme Court was doing in the Virginia case is saying, sorry, federal courts, you have no role here. We're simply going to leave this to the state courts in that case.
All right, Sarah Isgur, thank you very much. We'll talk more in the coming days and no doubt in the days after November 5th.